Welcome to one in a series of presentations by California Indian Legal Services on the Indian Child Welfare Act. Today's topic is the Forfeiture Doctrine, which was prominent in a case that is today still pending before the California Supreme Court. My name is Mark Radoff. I am a senior attorney with the program, and we'll begin. What is the Forfeiture Doctrine? The Forfeiture Doctrine is a scenario in any case, but specifically as it applied to juvenile cases, where a right or an issue or a claim or objection is forfeited. Usually it's going to be an appealable issue. In California, the law separates juvenile cases into two categories. There are dependency and delinquency cases. Both cases are codified in the Welfare and Institutions Code, Section 300 for dependents, Section 600 for delinquents. Dependent children are child welfare cases arising more or less out of the conduct of a parent, mistreatment by parents, abuse, neglect, or the caretakers, as opposed to or contrasted with delinquency, which is based on conduct that's wrongful or criminal by a minor. So one time it's the parents that do something wrong, or the family; the other time it's the minor themselves. Forfeit, and there would be a picture, if you could picture a chess set knocking over your king. You forfeit the game, you lose it, it's over. Forfeiture means it basically in this context that it is done, that there is no resurrection of that right. And so the general understanding with some of these rules, including this one, did not apply to dependency cases. Those are civil rules. But the case addressed this, and that's really what the ICWA issue was, is how far do other procedural mechanisms, including the forfeiture doctrine, apply to the dependency system as it applies to the Indian Child Welfare Act. So dependency cases, starting just a little bit more broadly, have 5 distinct phases. There's detention, sometimes called the initial hearing, jurisdiction, disposition, and then review hearings and permanency planning or termination of parental rights. Not all of the hearings are considered final hearings. Terminating parental rights at the end of the case, that's understood to be the final hearing, but detention, when a child is just removed and a decision has to be made whether to return a child, is not. It's on an emergency basis. It's not final, and it can be reviewed at subsequent hearings. Jurisdiction is where the court has to make findings and orders whether or not this is a case that falls underneath the court's adjudicatory powers. But the point being that not every single hearing in every single case is final and is appealable. The caveat to that is that disposition, which is the hearing where a decision is made about a permanent plan or whether to return a child, is considered to be an appealable decision. What's the importance, though, of an appealable order? Why would it matter? Because not every order can be appealed. Appeals, as a general rule, take longer in time. By comparison, there's an alternative procedure called a writ, which is a faster track to get a particular issue, a particular ruling reviewed. But most appeals are taken when the case is done and over. But disposition has been considered to be a final hearing for purposes of appeal. And so that is significant, because if it's not appealed, then the forfeiture of whatever rights or issues might have been raised is triggered. So the end of a case is the end, except when it's in the middle and it's a disposition. Why is it important in the Indian Child Welfare Act context? Well, I'll tell you, the Indian Child Welfare Act applies at all stages of a dependency case. And that includes the early stages, that includes the final stages. The rules of court 5.480 through 5.487 impose a continuing duty on the social service agency and the court to make inquiry about whether a child is Indian and to apply the act. And if the child is eligible or a member of a federally recognized tribe, then the act applies. But what happens if it's not applied, or if the case, if notice isn't made or inquiry isn't made in a dependency case? Parties need to object to that noncompliance. Saying the word "I object" makes a record. It requires the court to rule on that, and the forfeiture rule or the forfeiture doctrine says that if you don't appeal, you give it up. You've waived it. You've forfeited it. So the first step is objecting, and then the second step is appealing. And we're talking right now about the interim hearing, the dispositional hearing. Isaiah W. was originally a 2014 case. This is the citation that can be found in the Cal reports. There's another official site. I don't have it here, but you can find it. You can Google it or shepherdize it from the Cal Reporter citation to get the actual lower court case ruling. But that ruling now will be modified when the Supreme Court decision comes out. It was one of two cases heard by the California State Supreme Court in 2016. This is unusual in the sense that since 1978, when the Indian Child Welfare Act was adopted, only 4 times were there cases taken up by the High Court of California. 2 of those occurred this year. 2. So that's double what happened in the preceding 30 some odd years. So, and the last one, INRI WB, was, I believe, in 2012. So before 2012, all those years back to 1978, only 1 case was heard by the state Supreme Court. So in the last 4 years, it's heard 3. And this particular case focused on the Forfeiture Doctrine and its application to the Indian Child Welfare Act. And the way this case came to the court procedurally was the parent waited until the final hearing to raise the issue about not noticing the tribe and not applying the Indian Child Welfare Act. The mother had earlier claimed Indian ancestry, and the minor, Isaiah W., had been born with a positive drug test, positive toxicology report for marijuana, and at the earliest moment, I don't know if it was at the hospital or afterwards, but he was removed at infancy when he was an infant. When the mother was interviewed by the agency, she specified she might be Blackfoot or Cherokee. It is sometimes people mix up Blackfoot, Blackfeet, because one is Canadian, one is in the federally recognized United States tribe, but the agency didn't investigate one way or the other way. No action was taken at the initial hearing, which is the new word for detention, or at jurisdiction, and the juvenile court did not make a finding at the dispositional hearing about notice or the application of the act being the Indian Child Welfare Act. Notice, this is a slide that had a graphic behind it about taking notice of something. If the notice means that the tribe, the agency has identified a place to send the paperwork, and then the tribe, or sometimes it goes to the BIA, will receive that notice, and that will trigger their obligation to respond, or at least start the clock. It's a key component of the Indian Child Welfare Act. So without giving notice, which this might seem obvious, it is obvious, a tribe can't confirm eligibility. They can't intervene, which is to join the case as if they were a party. They can't do anything because they don't know what's happening. Notice starts when the agency interviews the parents or relatives or minor, or has some other information that would indicate the child is Indian. Federal law, although it does preempt state law, it allows California to form its own version of the Indian Child Welfare Act, and in some respects, California has exceeded the federal law, has added requirements, and that's permissible under federal law. So California is a stronger state law than the federal law, although federal preemption can trump state law if state law is inconsistent. So that it runs both ways in the scheme between federal and state law. This is the final judgment. Looks like we have an extra E, so judgment would be spelled without the E, Judgment, and that is the, as I was mentioning, the last event in the case. A final judgment is a technical term of art for court cases because it triggers when an appeal can be filed. You can't, if you're in a regular civil case, say it's not a dependency case, not a juvenile case, you can't just appeal a case while it's ongoing. There's a document that will allow the judgment to be entered and an appeal to be taken. Ordinarily, an appeal or an order doesn't have peel off issues that can be taken up to the next court, which is the Court of Appeal. But if there is an issue that is going to need immediate review, then the objection is the way to make a timely record. So I think I mentioned this before, but saying objection, objecting, noting that, filing something, however it gets done, whether it's done with or without counsel, that's the only way to preserve that issue, and it should be issue specific or fact specific, or if it has to do with evidence going in to the court's record that shouldn't, that the objection is the description of what the party believes is a wrongful procedural act by the court. In Isaiah W., the mother waited. She didn't appeal, and she may not have made an objection, I don't recall, but she did not appeal the court's failure to give notice or to apply the Indian Child Welfare Act until the back end of the case. So the tribe didn't have any role in that because the tribe didn't know about it, tribe or tribes. The dispositional hearing, it could be treated like overtime after the disposition because all of the issues that occur are post-dispositional. They may overlap with the prior rulings, but they're not newly going to be appealable. That doesn't mean that the mother in this case shouldn't have objected. She could have. She didn't in the later proceedings. But by not objecting, there is an ancillary effect that affects tribes too, affects other parties, and the minor and the other parent. As I said, California imposes a continuing duty on both the court and social services to inquire if a child is an Indian child. So the first inquiry is not the last inquiry. The Section 224.3 and the case cited there underscore that point. Court should and must make inquiry even after disposition, and that means that at every hearing, really, an inquiry by the court should be made about whether inquiry has been done by the agency. If there's any new information, anything to suggest that a child might have some tribal heritage or potential eligibility in a federally recognized tribe. There is a separate rule in California about unfederally recognized tribes that are only state recognized or not federally recognized. That is a permissive rule under California that is not in the federal rule. So the distinction would be between federally recognized and not federally recognized tribes. In addition to notice, a tribe can intervene in a case and be a party. They are, they're not just a fifth wheel, they're an actual party that has all the same rights to request discovery, to question witnesses, to object, to be present at each hearing, and to have notice of the other hearings. So there's notice that a case is happening, but there's also notice of events or hearings or what is at issue that have to be timely made to all parties, including the tribe. They have the right to transfer them, to take the case to their tribal court or tribal jurisdiction, and it can be stopped or objected to by a parent or the county if there's good cause. The later it gets, the more advanced the stage, the more difficult it is for a tribe to transfer. So by not getting notice until the end of a case, that prejudices a tribe's ability to transfer a case because it's by definition less early than it was in the beginning stages of the case. Membership can be affected by a tribe not being notified. Tribes are the party or the entity that can determine if a child is an Indian child or eligible for membership, and there's case after case on that. Santa Clara, 1978 case here, and also California citation, basically say that it's a matter of self-governance and it's a decision, the eligibility and membership is a decision left exclusively to the tribes. Under California's version, Cal-ICWA deems a tribe's membership decision to be conclusive. So the emphasis of that would be that once a tribe decides, it's not subject to review on membership by the state, by the court, by the agency. It's a tribe's determination. If the court doesn't tell the tribe about a case, or they don't inquire so that they can give notice, then they are in effect substituting their judgment on membership for the tribe. ICWA, though, involved more than the timeliness of the appeal. The first issue, the threshold issue, was whether there was reason to know whether this minor was an Indian child. The mother contended that she had a suggestion of Indian ancestry. That I'll say that better because there's some case law that says the mere suggestion of ancestry is enough to trigger ancestry. That's what the mother did. She did more than a suggestion. She actually told the court or told the agency that she had some Indian heritage, Native American heritage, and they didn't do anything about it, or they didn't do enough to notify those respective tribes. But that then served as a gateway, or in this case, a gate to applying the rest of the act. And the mother's waiver of that by not appealing, in effect, became a tribal waiver because the issue never was reviewed by another court that moved on as if it were a non-Indian case. And that delay in justice really is a denial of justice. That's the common adage. Specifically, the mother waited 1 year and 3 months to appeal, and as I said, the appeal impacts the tribe's rights negatively, because negatively in the sense that they don't know, they can't do anything. But also, when the disposition adopts a plan for reunification, that's a consensus plan, or at least it's designed to be a consensus plan with the parties, the agency, the parents, the team decision-making process, and the county attorney all playing a role, including the parents. And one of the issues that comes up frequently, at least should come up, is placement with a family member. Placement under the Indian Child Welfare Act with an Indian family member is a preferred placement and should be the first consideration. So a failure to notice the tribe impacts the placement preferences because they are a placement. There's no input by the tribe, and they may or may not be placed with an Indian relative. Waiting to notify the tribe increases bonding with a non-Indian placement. This is an ongoing issue. Longer child stays with a family the more bonded that family becomes to them. There's attachment in bonding. Bonding goes one direction. Attachment is the child to the foster parents or the placement. But the Isaiah W. court went out of its way to, they said the right thing. They said that the parents' forfeiture waiver is not a waiver for the tribe. But the delay in notification, which equals a delay in application, serves the same function. It delays the tribe's ability to undo that bond. California had a split of authority in its judicial districts on this issue, the underlying issue about foreclosure or forfeiture. The Pedro N. case was an earlier case where the mother had actually said the name of two different tribes, similar to this case, more specifically though, and that ruling said that she was foreclosed from raising compliance 2 years later at the TPR. I don't know, I don't remember if she had appealed or done anything, but the Pedro N ruling was if you don't appeal it then, if you don't ask for review, it's foreclosed, it's waived, it's gone. Dwayne P. took the opposite view. It's a later case in 2002, and said that parental inaction does not excuse the juvenile court's failure to give notice, that there's not a time limit on the parent's right to exercise compliance. That is the view that was advanced by the mother's attorney in Isaiah W. The objection expires under Pedro N, so if there was a visual here, it would be a visual of expired milk or an expiration date that is not the same as the ruling in the Dwayne P case. The reasoning behind the rule is to ensure that issues are perfected and brought while they're still meaningful, brought to the court, the lower court, as well as the appellate court. Dependency cases are not exempt from regular civil rules, but the question in this case is whether the federal ICWA undoes that application of those procedural rules. Again, the notice is the initial act that allows the tribe to determine whether a child is one of their potential members or eligible for members. It does look to me like this might be a duplicate slide. The determination of membership is a tribal issue, so I am going to skip this one. It looks to be a duplication. As do these. The preemption from state so the California law does not include a time limit, so there's not a for ICW cases, there's not a date certain by which a parent or a party or Indian custodian or someone has to say they believe there's an Indian child involved, and then to ask the court to take action. But the failure to do that means the court can keep going with the case as if it were not an Indian Child Welfare Act case. And then if the way this code is set up, if later information comes, they can apply it. But this conflict about the general rule about forfeiting a right and a waiver is still arguably inconsistent with federal law, which doesn't allow a court to ignore the issue if it has information. So a lot of that's going to be fact-specific, fact-driven, whether or not there's some document or some statement by a party or parent or agency suggesting or giving reason to know that a child is an Indian child. But the real issue is going to be whether or not the court had any obligation under the federal law to do anything about it. California social services and tribes are opposite. I think I had a graphic here of the number 6. So tribes are looking at it as a number 6, and the social service is looking at it as number 9. They're looking at the same exact scenario, but they draw different conclusions, and that's part of the problems that the agency is looking at it as an issue that has basically been asked and answered, and then moving on. And if it doesn't apply, they will do what they can to achieve permanency. Whereas the failure to do that is something that the tribes and tribal representatives will want to raise, even if the parent was delinquent or purposefully didn't notify the court about the tribal affiliation. So federal and state law both have an after-the-fact procedure called invalidation. Invalidation is a way to undo an act by the court. It's just what it says. It's an invalidation, and there's no time limit on it. So even when cases gets to TPR, termination of parental rights, it can be undone. The Holyfield case, the Supreme Court case in Mississippi, Choctaw versus Holyfield, I believe, was a procedural invalidation of an act, and it's not one that sunsets at the end of a case with all other issues. So invalidation really serves, if you want to take a 30,000-foot view of it, as a de facto appeal after the fact. So this is a little bit more specifics. It allows a parent or tribe to undo the order for noncompliance. It un-forfeits a violation, and it's a separate remedy. It's distinct from the regular rules of appeal. You might reach the same point by invalidation because you're asking for a new trial or a new set of hearings to occur, but it's a remedy that's earmarked, it's circumscribed in both the state and federal law. It's like a rooster in the morning. It just keeps crowing. It stays there. There's nothing that will eliminate invalidation. So in other words, you cannot forfeit an invalidation. I think I had a picture of a rooster here, but the invalidation is always possible. It would be the best practice, though, to object. That's always the best mechanism to preserve or to perfect an issue. Isaiah W, and the case would actually be Isaiah capital W. We don't know what's going to happen. We haven't seen the decision, but the court in oral argument appeared concerned about a blanket waiver of the ICWA and ICWA compliance by a parent. As I said before, tribes are concerned that a parent's failure to act can adversely affect the case management issues of all of them and the tribe's ability to participate. The invalidation can, as I mentioned a moment ago, undo a forfeiture. So if a tribe learns about a case late, it can intervene and invalidate. The forfeiture rule is an exception to the general rule, but it's not an all-the-time rule. And one of the justices made note of that the general rule does not control in every scenario, and this is a particular alignment of facts, which it may be that the court does not allow the lower courts to disregard the act when a parent fails to object. So that would mean basically that would be an affirmation of the continuing duty to apply the act. It's not just a continuing duty to ask about it, it's a continuing duty to apply the act. Best practice would be object early and often to every issue, and there's nothing that would require or preclude a party or parent or anyone from notifying tribes separately from a county. That does happen from time to time, and that would be another mechanism to make sure that the tribes get involved if they are able to. So we'll wait and see. The decision should be out this summer. I think they have 60 days to issue a ruling, and we're probably about a month from the oral argument of May 3rd. So anytime now, we should have a ruling on Isaiah W. And there was another case, Abigail A., on the requirement of the county to assist in enrollment of a child before they, sometimes before the case has been decided to be an Indian Child Welfare Act case, but also as an adjunct to the regular duties that the agency undertakes when they step into a parent's shoes, and enrollment of a child is similar to other duties that the county undertakes. Those two cases, Abigail A. and Isaiah W., are pending before the Supreme Court. They were heard on the same date, and they will likely be issued in a ruling around the same time. So stay tuned for that. And that would conclude this presentation. Thank you for listening. There's the contact information if you have any questions or need additional information. Thank you.